Good afternoon. The title of today's talk is The Devil's Name is Process. What I hope to show you is how many of the difficulties and injustices faced by migrant workers can be traced to a failure of process. Whose process? Well, I hope that will become clear by the end of the talk. Singapore gives the impression of a first world city with our gleaming skyscrapers and relatively efficient infrastructure. But under all that steel and glass is a grim reality. It is easy to assume that just because we look like a first world city superficially, because our hardware works that way, then our software is also of first world standards. And by software, I mean the way we operate things, our attitudes towards people, or our systems for dealing with failings. On paper, our laws may look fine. We have laws requiring the licensing of job agents and regulating the fees they can charge. We have the Employment Act that sets out salary entitlements, some other laws that extend medical care by right to foreign workers, and the Work Injury Compensation Act, which on the face of it provides a fair, no-fault mechanism in the event of a workplace injury. On the face of it. Laws, however, don't exist and don't realize the legislative intent alone. There are all sorts of additional rules and bureaucratic processes that put the gears into motion. There are human attitudes that affect the operation of these processes. And when the processes fall apart or get jammed up, or when humans are motivated in ways alien to the law's objectives, that's when things go wrong. I will show you in this talk the myriad ways in which things go wrong for the migrant worker in Singapore. Sometimes the processes supposed to support a law or to give substance to ministers' claims about how good things are unsound. They are so poorly designed, they just don't deliver the expected result. The processes may contain inherent bias, usually through failure to correct for pre-existing conditions or failure to recognize that different parties have different ease of access to the process. Or they may contain loopholes which one side happily exploits, thus undermining the results. Other times, the designed processes are sound, but the people implementing them have conflicting objectives, usually goals that they will not admit to, and they stymie the process by twisting it beyond recognition, or interpreting the text beyond reason, or by ignoring it altogether. Sometimes they simply fail to enforce the provisions. Occasionally, TWC2 has found that no clear process exists. There is no available route to an outcome, even though ministers or senior civil servants claim that such and such an outcome is a policy objective. Before going further, and since many of you are from other countries, I will spend one slide to explain a bit more about the deeper political context that shapes the operation of many things in Singapore, not least the entire approach to the foreign worker issue. Firstly, this is a government that uses economic growth as its lodestar. Virtually everything is tamed to serve the objective of economic growth. And more, economic growth is often seen through the perspective of trickle-down dogma. Ministry of Manpower officials have on several occasions said that we will operate our policies in a manner that is, quote-unquote, business-friendly. So when the interests of workers are opposite to the interests of business, the very starting point in the state's approach is already a handicap. Secondly, in Singapore, the question of rights is off the agenda. Appealing to rights cuts no ice. In fact, just by raising something as a matter of right, we'll see officials raise the drawbridge and take up defensive battle positions. Care and concern, however, is admissible. Partly it is because it reinforces the classism that is so much a feature of Singapore today, the privileged, the powerful, demonstrating a generosity, almost a noblesse oblige. that at the same time cements, exalts their status, but also because such acts help to smoothen the hard edges of government policy. But never forget that care and concern cannot take on a life of its own that begins to undermine its subordinate position to economic growth as the primary, non-negotiable objective of the state. For example, we will not impose obligations on employers that raise too much the cost of doing business. With respect to non-citizens like migrant workers, care and concern has to be understood as either 1. Private charity, or 2. Legal obligations imposed upon employers. The government will not contemplate socializing care and concern when it comes to foreign workers. The idea that taxpayer money may be used to help non-citizens, even though non-citizens pay tax, is anathema. As a result, subsidized medical care is not available to foreign workers, even though by many measures they have the lowest salaries in Singapore. There is one last point I need to make here. The government collects about $5 billion a year in foreign worker levies, making up about 8% of the government's budget. When a state budget is so addicted to this regular source of revenue, it creates a further barrier to change. Any major policy proposal with possibly dramatic effects on the inflow of foreign labor becomes harder to push through if there is a perceived risk to state finances. Let me touch on a few other background elements before we get into the details. The state uses macro tools to regulate the total number of migrant workers in Singapore. The two chief tools are a form of quota imposed at company level and the monthly levy. The second thing to note is that the state sees migrant labor primarily through the lens of internal security, orderliness in terms of their social, civil, and work behavior, and the prevention of immigration violations drive much of their priorities. Justice, fairness, liberties, human dignity, they're all a distant second. Singapore extends a lot of freedom to employers. They choose who they want to hire and, subject to a veto by the government, bring in. They can also fire at any time. No valid reason needs to be given. When an employer has terminated a worker's job, it is the employer's responsibility to repatriate the worker. The state has devolved this policing power to the private employer through the $5,000 security bond. If the employer fails to repatriate the worker, he loses the bond. But the outcome is that employers come to believe that they have some kind of proprietary right over the human being that is the worker. He believes the state has conferred on him those rights to control, sometimes even to confine the worker, because his own money, $5,000, is at stake. On the last point, to say the social safety net is left to employers is rather a misnomer. There is nothing very socialized about it, except perhaps that the employer can insure his risks to a degree. But the safety net, for what it is, huge gaping holes and all, is really no more than a set of legal obligations imposed on the employer by various laws. But if the laws are not enforced, what becomes of these obligations? If the employer has gone bankrupt, what happens? And that's what we're about to see as we go through 4 segments in some detail. In each, I will highlight a few ways in which matters go wrong for the migrant worker. These segments roughly relate to the chief areas of complaints that TWC2 hears about from our cases. In other words, we have numerous examples of them. They represent rather prevalent problems.